court rise if able.
No. Sorry, I should have asked my clerk to do some adjusting in my chair before we came in. Sorry, it's rather undignified, but you done it? Thank you. Much better. Yes, thank you. Actually. Ms. Ashrew, I think we should say that we have been doing some work over the short adjournment, and we now understand rather better why you have doggedly, if I may say so, addressed your submissions on, or parts of them, on the basis of perversity, and slightly resisted our attempt to reformulate what the real issue in the case is, because looking at it again in the light of your submissions, it seems to us at least arguable that that is indeed ultimately how the EAT did decide it. And to be fair to Mr. Jones, that's really what he is defending in his submissions. So I'm sorry if we made life more difficult for you. Having said that, I think we have covered all the ground. We see in your both from your oral submissions and from your skeleton argument, you have, I think, covered nearly all the points raised by your grounds of appeal, except for the Jaffrey point, and except for the British Airways and British Aerospace and Green point. So far as the latter is concerned, have I understood this correctly? This is surely the point which apparently was argued in the EAT, but they said they didn't need to deal with. And although there is a respondent's notice, the respondent's notice is not in order to rely on that point. That being so, I don't think we need to go there. If we discover that Mr. Jones goes there just the same and persuades us he's entitled to, well, you can deal with it in reply. But at the moment, we don't see how it arises. We are still very willing to hear from Mr. Wilson on the Jaffrey point, though actually the Jaffrey point is really, isn't it, largely the perversity point again, because if this was a true if this was a true perversity point, then and they were right to find the decision of the Employment Appeals Tribunal perverse, that necessarily means that there was only one conclusion they could have reached to, and therefore no need to send it back. If, however, as we were flirting with this morning, this is more a question of the tribunal having asked some wrong questions or given wrong reasons or not given sufficient reasons, then that would be a classic Jaffrey situation. And you would only get over that. Mr. Jones would only get over that by saying that there was only one answer to which they could have come, which is a point he's running anyway for other reasons. Does that make all that make sense? And I think the upshot of it is there's very little. We're not saying we won't hear from Mr. Wilson, but there's very little that either you or he need deal with.
Thank you, my lord. I'm grateful. I think that is a fair summary of the Jaffrey point. Of course, we say the tribunal should have never got to the perversity point because it wasn't before them. But I think that is a fair summary of the Jaffrey point. Perhaps if I could just take a step back, because there are a couple of things that I was.
Yes, no, do. We're not closing you down at all. We just wanted to update you with having, as I say, done some rereading in the course of the lunch adjournment where we got to. Yeah, of course, my lord.
Just as a footnote to that, if I may, because this may help to explain where, at least speaking for myself, I've been coming from.
Yes, please.
I've been looking at the grounds of appeal before the EAT. Can you just help me with that? Have you got the supplementary bundle?
So the grounds of appeal before the EAT are actually in the
Page
core
14.
bundle. Sorry.
Oh, sorry, I was looking at the skeleton argument, which summarises ground J as it was known.
Yeah, so the ground J itself and the decision on the SIFT is in the core bundle. So if we look at tab 6, ground
Sorry,
J,
which bundle?
the core bundle, tab 6.
That's, yeah. Which page?
Page 71.
Because as I understand it, this ground J is the only ground that was pursued.
Yes.
There had been 3 grounds which passed the SIFT stage, but there was one that was pursued at the substantive appeal, and that was ground J.
Yes, so 2 grounds had passed the SIFT stage, 1 was added at the Rule 310.
I see.
And then that was withdrawn or not pursued at the EAT, and ground L was not pursued at the EAT either, so ground J was the only one.
Right, that's very helpful. And we see the formulation of ground J at page 71 of the core bundle.
Yes.
That's fine. I was looking at the skeleton argument in the, and as I understand it, this is the skeleton argument in the EAT at supplementary bundle page 14.
Yes.
And that has heading ground 1 J. So I assume that is ground J that we've just been looking at.
Yes.
And the submission included, we can see paragraph 2. And I always search, whenever somebody tells me that something is a ground, I always try to find out what actually is it. What's the fundamental complaint you're making? And I'm afraid, possibly erroneously, I had understood that the gravamen of the complaint appears at para 2.4. The tribunal did not consider this question at all.
Yes.
Or, in the alternative, inadequately. That's again a classic pleading technique. If you can't get home on the first point, you always say in the alternative, they didn't do enough. I get that. But I just wanted you to be aware, I've been trying to make sense of what was this appeal actually all about?
Well, I think this is one of the issues in the case because it hasn't been entirely clear what the appeal is about. So we see ground J at page 77. We see the decision on the SIFT at page 71. Sorry, we see the decision on the SIFT at page 77.
Right.
And of course, you'll realise that the first sentence is not entirely a full sentence. So it has always been difficult to know what the appeal is really about. Yes. And then, of course, we get the claimant skeleton argument in the EAT, which you've rightly referred to. So there has been somewhat shifting sands throughout the appeal process.
I hope my Lord will forgive me for having...
No, that's been helpful. Well, we had both. I haven't been able to, as a matter of archaeology, to work out exactly how I'd come to the same position as him, but I suspect it's from reading the same materials. And I don't, but there we are.
But it certainly seems from paragraph 32 of the EAT's decision that actually it did decide this on perversity grounds, albeit dressed it up as the tribunal having overlooked elements of consultation. And this is
you may be right about that, and you referred to your submissions about that, and you may, I genuinely mean that, you may be right about that. But another complaint you make is that even if that's not the right way to look at it, your fundamental complaint, I think, about para 32 is that that's a clear instance of the EAT substituting its own judgment for that of the EAT, for that of the ET.
Exactly.
Which it can only do if the ET's decision was obviously wrong.
Exactly.
Yeah.
And we say it wasn't obviously not wrong.
Well, I found that very helpful, if I may say so.
Thank you. Just to take a step back, because I was asked how the claimant put the case in the tribunal, and I've checked my notes on the tribunal hearing as well. If I could refer you first to page 122 of the core bundle behind tab 11.
Yes.
It's paragraph F.
Yes.
So you'll see on the previous page, section 3, failings in the redundancy process. Paragraphs F and G which were relied upon as to the issues with the consultation. So it says the company did not involve me properly in the redundancy process and did not give me the opportunity to challenge the scores, express my views on the matter, and then the claimant refers specifically to the number in the pool, not knowing the number in the pool, not knowing his scores, not knowing positions, lengths of service and scores of others, and not having the critical roles report. And then paragraph G, the company not stating why he was being made redundant. So that's the way the claimant put his case on consultation in the T1. He put his case in a similar way in his witness statement. So whilst he went further than he did during the consultation period and in his ET1 in relation to criteria and scores, there's nowhere that explicitly shows him challenging the timing of the selection criteria as such, or not having an opportunity to challenge the selection criteria. I've also revisited my notes from the tribunal hearing. There was no challenge, as I thought was the case, in relation to the origins of the selection criteria coming from the UK.
Yeah.
Now, whilst I have a recollection of taking or attempting to take the EAT to the documents that I took you to, I can see in my skeleton argument that that's not entirely clear. So I can't put that point forward with...
Sorry, I just haven't. I answered your first point. You confirm there was no challenge to the selection criteria
coming from the UK.
Coming from the UK.
But I appreciate it may not have been clear at the EAT that was disputed by us because,
yes,
as I say, it didn't seem to be a relevant point on the appeal.
No, so that's very much what you. But that's what you said.
Yes. And having looked through my notes, there was no challenge of Miss Hancock or Miss O'Donovan, who were the relevant witnesses, as to the claimant not having an opportunity to challenge the selection criteria.
Not having an opportunity to challenge the selection criteria before they were implemented.
Yes.
Yeah.
Now, the claimant's focus in the tribunal was on ulterior motive or the influence of someone at the client. It was on the pool for selection. It was on various parts of the selection criteria being subjective.
Hang on 1 second. Pool, is that the point that the Warsaw people should have been included?
Yes. And it was on the claimant not being provided his scores or the scores of others during the consultation process. And the point that I came back to about the timing of the scores, that became more of a focus in the appeal following the evidence, where the claimant said that that meant that the decision, final decision, was predetermined. Now, the learned judge did go through what she understood to be the claimant's arguments in closing submissions, and she ended with the question, is there anything else on procedure? And the answer was no.
You're reading from your note there, are you?
Well, I've checked my notes over the last...
Yes, I'm sorry, but I just wanted to...
Yeah.
So what you're telling us, I mean, and I only have this from you, not saying that's doesn't mean we can't rely on it, but there was a closing submission process. He went through his, and the judge, as it were, attempted to establish with him what his criticisms were.
Yes.
And then at the end said, "Was there anything else on process?" And he said no.
Yes, correct.
Well, apparently that's what we ought to expect. So, yeah.
Now, of course, whilst the claimant was a litigant in person in the tribunal, he was represented by his father,
yes,
who is a retired solicitor, I understand. And they did mount a detailed challenge in respect of specific things and in a very specific and structured way. So this is not a case where a claimant litigant in person has just said the dismissal was unfair. So yes, it can probably be understandable as to why the judge then dealt with those points specifically in her discussions and conclusions. Now, if we look at the claimant's skeleton argument in the EAT, at no point there does he mount a challenge as to not having a chance to challenge the selection criteria before the consultation took place or before the scoring took place. And equally, the EAT itself doesn't address any such point either in its judgment.
No, I mean, what it talks about is this phrase workplace consultation, which I don't find the workforce consultation, which I don't find particularly apt, but he makes clear what he means by it, so that's fine. And I think, again, this may be my own reading, that the principal thing you might have expected there to be consultation about was the selection criteria. That's influenced by my experience of having cases about that in the AT. But it's fair to say he is talking about everything that could have happened at that stage. So he's also talking about whether there was a redundancy, needed to be a redundancy situation at all.
Yes, it's not entirely clear. It is a very broad comment from the EAT.
Yes.
It's not entirely clear what they found to be the real criticism of the process.
If my lord will forgive me, it may be worth just looking at how they formulated the ground, because this is apparently how they understood the ground. It's in paragraph 3 of the EAT judgment at page 53. And like my lord, I took the opportunity over the short journey to have a look at the EAT judgment again. And I was struck, if I may say so, at how broadly they actually formulated the issue they had to determine, because they formulated as only one ground that there had been a failure to consult properly.
Yes.
Now, they do develop that, multiple aspects, and you can all read that. But I think one of your fundamental criticisms of the EAT is that right at the outset, in giving themselves that self-direction, they've gone wrong in law.
Yes.
Because they're asking themselves the wrong question for the appeal tribunal.
Yes.
Is that right?
Yes, exactly. And then they don't even go on to answer that question, because they go on to say about general workforce consultation, which is something different to the way it had been put in the EAT and below. And just to come back to your point, my lord, on the general workforce consultation.
Yes.
I think the problem with this is that the EAT says in terms that it would be expected that general workforce consultation would take place in addition to individual consultation. And the immediate question is, well, why? Why can't the same things that are discussed in individual consultation be sufficient? So this is the Belouan point as well. In that case, the decision that the ward would close and there would be 19 redundancies was decided before any consultation. The staff were effectively informed of what the selection criteria would be, but there was no consultation on it. And then when it comes to the consultation, the EAT there found as part of the EAT that consultation process that was followed is what.
Well, we found that the ET was entitled to find that it was fair.
Well, the ET found that it was unfair.
Oh, sorry, yes, it was unfair, yes. But on the consultation question.
Yes.
Yeah.
So the ET found that it was unfair.
Yes.
And you accepted the challenge to that on appeal, and said that the process that was followed is what would be expected of an employer in this type of situation. But that didn't get over the main point, which was about the nature of the selection process, recruitment criteria rather than.
Well, I mean, we're only talking about Bill 1 because I mentioned it before lunch, and I mentioned it before lunch because clearly the EAT thought it was a problematic decision, but it was a decision on its own very particular facts.
Yes.
And quite carefully one which was in terms of what the ET was entitled to conclude rather than laying down any enormous general principles.
Yes, absolutely. And I think Belouan goes no further than to say that in a redundancy consultation process where there is no union, practically the scope for effective consultation on certain points may be more limited, and the ET failed to take that into account.
Yes, I mean, certainly if, just really thinking aloud for a moment, I don't want to spend too much time on this, if by general workforce consultation, where there isn't a union, it's meant you must get all the workforce together in a room and sort of consult them collectively, whatever, give them the opportunity. It's hard to see where that would come from, but that's not the same as saying that the kinds of issues that you would discuss if there were a union at an early stage, you shouldn't discuss with individuals, or to give individuals the opportunities to give their views.
Yes.
It's not clear to me exactly what the EAT is saying about that, but.
Well, no, quite, and that was part of our challenge to the introduction of this concept. But my learned friends in their skeleton argument at paragraph 45.2 say, by workforce consultation, the EAT evidently meant consultation with the workforce as a group rather than individually.
Well, maybe, but
it's not
okay.
entirely
Well,
clear
we'll have to hear Mr. Jones on that.
It's not entirely clear why that would be necessary at all if the same information is provided in individual consultation meetings. And we say here that that process certainly did take place. With your helpful guidance, my lord, in relation to the remaining points, I think the only final thing that I would want to draw your attention to is in Ananda Raja, and I've set this out in the skeleton argument, so I won't take you to it, but that makes it very clear that tribunals should not be preoccupied with various guidance, and all they are required to do is to apply the statute.
Incidentally, it's very old-fashioned of me, but nobody seemed to refer to any. Maybe there isn't any or any that's no longer in force, but is there no ACAS guidance about redundancy consultation?
There's not an ACAS code, there is ACAS guidance.
Okay, well, if there isn't an ACAS code, well, I just wondered, but I don't really want to open up a whole new.
Thank you. With that in mind, just the final point I would make is that this point about conflating early consultation with formative consultation, and the two are not necessarily the same. Now, my learned friends say that the EAT didn't do that, but I think where we've seen in paragraph 20 of the EAT judgment, where it says in terms that early consultation is necessary to fairness, it clearly did do that, but my submission...
Paragraph 20.
Of what?
Of the EAT judgment.
Yeah.
Just remind me, where do you see that word?
So this is where the EAT addresses what it considered to be a conflict between McGann and Beluan. Halfway down, sorry, just above the second.
Yeah, I see. Yeah.
As a general proposition, however, we prefer the conclusion in McGann that early consultation with the representative or the employee is necessary to fairness.
Yeah. And why is it wrong to read that not in a temporal sense, but in what I would call a conceptual sense? In other words, early means at a stage when it might make a difference.
Yeah.
Well, that's our point, which is formative means at a stage when it might make a difference. That doesn't necessarily mean
why do you read what they're saying as being any different from that?
Well, because early suggests that it needs to happen at the outset of a consultation process, whereas formative accepts that it may happen later, and it will still be fair provided that there's open-mindedness of the decision makers. And we see at paragraph 20 the strictures that the EAT puts in place on when there could be a departure from certain guidance make it, in my submission, an elevation to a principle of law. So it talks about if it would be futile to do that, or it doesn't make the process unfair. And I say that's an unnecessary fetter on the tribunal's discretion, which is not permitted under section 98.
Now, I am beginning to become, although Mr. Jones, as I say, in the nature of things won't need to take as long as you, he does need some time. Is there anything else?
No, that's everything. We've obviously dealt with each ground of appeal in the skeleton argument, so I won't take up any more of your time on that. I'll hand over to my learned Julie.
Well, certainly, but do we really need to hear from him? Well, we'll hear from him for a moment or two, but Mr. Wilson, sorry, that's not a very encouraging start, is it?
Do we need to hear from you?
Yes.
My lord, I can take the point very briefly.
Yes, well, I think you need to, yeah.
Over labour the Jaffrey point. You will, of course, be very familiar with the principle of Jaffrey. And I would draw attention to two observations which you will be particularly familiar with because they were made by yourself at paragraph 44 in Jaffrey.
We needn't even turn it up at the moment, I think, because
No. It being that the question of the fairness of a dismissal is something which is peculiarly within the province of the Employment Tribunal.
Yeah.
And secondly, the observation that you made at paragraph 47, having expressed some misgivings perhaps about the approach to remission to the Employment Tribunal,
Yeah.
but you observed that that could be mitigated as long as the EAT always considers carefully whether the case is indeed one where more than one answer is reasonably possible. Now, in my submission, putting to one side the perversity point, because plainly if the EAT decided this case on perversity grounds, it erred in doing so. But I think it is worth observing that even if the case is looked at on a failure to give reasons or asked itself the wrong question basis, the EAT's judgment itself has a wealth of sentences and paragraphs that indicate that this was precisely the sort of matter that needed to be turned to by the tribunal by observing gaps in reasons. I won't ask you to turn them up, but as a matter of record, I would just observe that it's apparent, in fact, from the very first line of the EAT's summary, but also at paragraphs 20, 21 and 30 of the EAT's decision. My lords, this very plainly was not a case in which it could be said that there was only one possible outcome.
Okay.
This wasn't a perversity case like Williams or Freud or Rowell, nor was it even a case like McGann, where, for example,
Sorry, my chair keeps collapsing. I don't want to keep going. I'll sort myself out in a moment.
Nor was it a case like McGann, where which was essentially a pool of one case, whereby the selection criteria, by their very adoption, necessarily identified someone for redundancy. This was a much more standard redundancy case, and the reality is that even if the Employment Appeal Tribunal was right that the ET had erred in law, it was for the ET to fill those gaps in the judgment, the ET having heard all of the evidence and the submissions in the case. My lord, I don't propose to say any more.
No, thank you. That's been very helpful. Well, I'm just to see if I can sort. I think, and just to see if I can sort out my chair. If necessary, my lord will call for assistance.
But I summon. I think it's not the court I normally sit in, and.
If it's any assistance as a temporary, did you want one of these chairs? If that was really causing you difficulty.
No, I think could you email Jinky?
Yeah, sure.
You'd rather? No, that's fine. I'll cope for the moment, and my clerk will come and do her magic. And I just have to be very careful where I put my feet for the rest of the morning, the rest of the afternoon. Mr. Jones, thank you very much.
My lord, I'm going to start with the facts, and as I go through those, principally by reference to the Employment Tribunal judgment, I will draw out some remarks on fairness of the consultation procedure as I go along.
Yes, that's fine.
Could I just flag that I will, after doing that, come to the question of what was actually put in the Employment Tribunal? I appreciate that will be uppermost in your mind.
Yes.
But first, if I just go through the facts, and as I say, make some observations along the way. If we start, please, at para 26 of the Employment Tribunal. At the beginning of June, the HR team supplied the London manager with a matrix, asked her to assess her team members. She did so, entering results in an Excel spreadsheet. I'm afraid on the question of fact, which you were addressed on, I can't say whether my learned friend is right or wrong. What I can say is that this tribunal proceeds on the basis that it came from the United States. And my lord, moreover, as you pointed out later on at 51, that's a factor in their favour, as it were. So if one were to now start unwinding that sort of comment, it could have wider ramifications. I should say, as I see that this, anything turns on this, if I put it that way, but I can't concede that this is an error in the judgment, because those emails, in certain respects, appear ambiguous and
It was clearly
a building block of the decision.
It was a
Basis upon which the judge E.T. decided it.
yes.
Sorry, I think just to clarify, I think what my lord may be putting to you is that it was a building block of the E80's reasoning.
Yes.
Yes, I see. Yes, I
Well,
apologise.
yes.
Yeah.
It's a. Yeah. It's there in the E.T. decision. It's a building block of the E.A.T. decision.
It's a building block in the ET's decision in respect of a point which goes in my learned friend's client's favour. That's
Yes.
paragraph 51. So it actually is baked in there as a building block on a
Yes.
different point.
But as the law says, it's also relevant to the E.A.T.
It is also relevant to the EAT, but can I come on to that when I get to the EAT's judgment?
certainly.
It plays a minor role in that, which is why I say
But
it's not. It's not.
if I may say, so you're taking a very sensible approach in that, but I just, in case there's anything you want to say about it, I take your point about paragraph 51, which we looked at earlier, and made a point that it was a point in, at that stage in in respondent's favour, but the real point was in their favour was that it was a standard package. The point would be just as true, but the standard package had come from London or from America.
Yes.
Yeah. Okay. Thank you.
But back in 26, could I just
Yes.
highlight that the way in which Miss Hancock completed this exercise was she said she used documentary evidence when available as a check, but otherwise relied on her own knowledge. In effect, the documentary evidence is limited because she'd only started the post in April 2019 and didn't have access to previous reviews. And if you just please turn forwards to paragraph 52, you'll see that it is recorded that the criteria for selection relied heavily on the judgment of the team manager, something that would be difficult to check by reference to objective criteria. And I'm going to come back to that, but just to put that into the chronology there, that is the way that it was done. It was very heavily based on her own subjective assessment of the individuals in the pool.
Just hang on 1 second. I'm not saying you're wrong. I just want to see exactly where we're left. Yes, I see. Yep, thank you.
And back then, on page 86 of the bundle, we know at paragraph 28 that rankings were given to the 16 relevant employees, and the claimant was scored the lowest. I should say it is common ground, my learned friend made this clear as well, that the date on which that was done was the 10th or the 11th of June. That's
Yes,
also
yes. Looking at your skeleton again over lunch, I saw that it's an important point for you.
At para 29, the tribunal finds that it was on the 18th of June that HR determined 3 roles would have to go, 1 from ADP and 2 from the GS contract. Again, that isn't controversial, but it's really important because one of the questions we come on to is consultation over alternatives to redundancy, but there is a finding that on the 18th of June, they had decided that 3 roles would have to go, including 2 from the Goldman Sachs contract. In this connection, you were shown, can we go to it please, page 37 of the supplementary bundle.
Yep. My client's just come to do her magic.
Oh, no. Can you just look at what we did before?
It's on the other side, but you might go down again.
It might go before. You're all done very well. Which that? I've been using the one on this side. I see. That's what I'm not doing. Is there one literally outside?
Let's just rise for a moment. I'm sorry.
Call guy at the table.
Does this one go through? No, I think I need to manage. Now I know how it works. Can't get it open.
rise if able.
Thank you, Dee. Sorry about that little bit of comedy.
On a supplementary bundle, page 36, please.
Yeah.
We had just looked at the fact that the decision to make 3 or 2 in this team roles redundant was taken on the 18th of June. I just want to show you the emails on this because you're shown one of them, but I think not this one on page 36. This is from the US. Hi, Lucy. Thank you for this information. I confirm we will need to move forward with eliminating 3 roles, 1 on the ADP side, 2 on the GS client side. And then there's a reference to the criteria spreadsheet, which was apparently still being looked at that point. But then if you look further down, it says, in the US, we're paying 4-week notice period. And then the next paragraph, our timeline for notifications is June the 30th. This was on the 18th of June. Our timeline for notifications is June the 30th. I know it's tight. Please let me know if you think there'll be issues with moving this fast. I did review the link you sent me yesterday where it stated that if we're impacting less than 20 people, there's no set rules on when to begin consultation before giving redundancy notice. So I hope we'll be okay.
Mm-hmm.
And then there's the email back on page 37, which you were shown, in which it is said we would normally consult for a period of at least 2 weeks, and there are then discussions about how that's going to play out. And I only show you that because I think my learned friend was making the point, well, look, you can see these emails and the 2-week consultation period was set by the UK office, but when you put it in context, they're under this pressure from the United States to move as quickly as possible. And as I'm going to show you as we go through the facts, the central problem with the way the consultation unfolds is that everything is telescoped and things are done on top of each other and at the same time in a really short window. So back on page 86 of the core bundle, please, if I can just pick it back up there. I took a detour, but with paragraph 30, you've seen that the timetable was set on that day. Paragraph 31, again, you've seen this, but this was, it was called to the meeting. He heard that morning from his colleague. He was told there was a reduction in client needs requiring some redundancies and that the purpose of the meeting was to inform him of this, enable him to ask questions and for him to suggest alternative approaches to the reduction in demand. And can I, again, I'm sorry to jump around so much. There's only, I think, a couple more that I need to go to. I do want to go back to that letter that he was given at some
Yes.
One was read out, you mean, or the one that's
38. Well, both actually, but both. So at 38, he is told, and we saw this in the factual findings, but he's told in the main paragraph there, the purpose of the consultation period is to enable the company to inform you of the proposed changes, to give you an opportunity to ask any questions you may have, and to give you a chance to suggest an alternative approach to the situation which we may not have thought of. Just pause there. The decision's been taken by this point. That's a finding of fact. The decision to make the 3 roles redundant has been taken by that point. They're saying to him that it's to give him an opportunity to suggest an alternative approach. Further on in that paragraph, your role is at risk of being made redundant. No formal decision can be made until the consultation process is complete. And then they reference the selection matrix scoring process. And over on the next page, on page 40,
well, I mean, yes, the point about no formal decision will be made. I mean, you may say, well, that's not realistic, but although we were focusing more on the selection criteria rather than on the numbers to go, surely Ms. Ashiru's point would be the same. If you came up with a good reason why actually 2 people didn't need to go from the GS group, we'd obviously reconsider. Well, we've taken a decision, if you like, with a small d, because you can see that but there's always got to be an iteration between proposals to which people react, as long as they're not finalised.
I fully accept that, and I fully accept that in principle, if one could have a decision maker with a wholly open mind through the whole process, then that would always be an answer to any timing point. You could always say, well, you could have raised this issue later on in the process. 2 points, though. The first is, the reality in any of these situations is the more you make decisions
Yeah.
as you go along, the more entrenched they become. And that is true of all of the kinds of decisions that we're looking at here. So approaching an employee before you've decided whether it is necessary to make redundancies is to approach them at a stage in which you truly are approaching it with a formative mindset and you truly have an open mind. Doing it when you've reached a preliminary view, which is common, that is the norm, my lord will know that, a preliminary view. Of course, there always has to be some sort of preliminary review because otherwise you wouldn't be consulting on redundancies, but approach them when you've reached a fairly firm, if I can put it that way, preliminary
Yeah,
review.
I mean, there's lots of law about this in the context of collective consultation.
Absolutely, absolutely. So first, it's a spectrum, and the point which I'm making in that regard is that the factual finding is that they had made the decision. But secondly, you then have to ask what information is being given to the affected employee to enable them fairly to engage in the consultation. And that is the core of the British coal and public law principles by analogy. And they give him nothing because, my lord, the way you put the question to me was, he could have said, you don't need to make 2 redundancies. He didn't know they were making 2 redundancies. They didn't tell him. They didn't tell him what the pool was. They didn't tell him anything about what the client had said in relation to the need for redundancies. And the references that crop up to critical roles report is just to the report, which has never been disclosed, but which was referred to in the appeal hearing, actually.
Well, it's never been disclosed.
It was never disclosed. It was never disclosed. But the only point about that is, as we understand it, that is the report which Goldman Sachs produced, which explained their anticipated demand for the services that were being supplied. And of course he knows that this is because of COVID. Of course he knows that there's a big reduction in demand. But he's not put in a position to make any sensible suggestions. What might they be? Let's go down to 4 days a week. Let's think about other ways of allocating work between ourselves. Furlough, I don't know if you picked up in the judgment, but the time for the government scheme had passed. Only just. So in fact, what happened is they missed the deadline to get government funded furlough and then suddenly introduce their own redundancy scheme. But there it is. That point hasn't been made. I just make it in passing. But the point is, you can furlough without subsidies. That is something which an employer could do. And in fact, if you don't give your employees the basis on which to understand your business decision and you don't tell them it's only 2 out of a team of 16. It's such a small number. He originally anticipated it was going to be much more than that. So it's only 2 out of 16. It's very difficult for them to make sensible suggestions on how to avoid redundancies. So I'm taking.
But does this reflect? I appreciate this argument will be taken too far, but does this reflect to some extent there are just areas which are so much a matter of management policy and decision that it's not realistic, or fairness doesn't require that an individual employee who won't know the books, won't know the financial situation, won't know the client relationships, can sensibly say, well, you should challenge the idea that we need to, you go back to Goldman Sachs and say we don't need to get rid of these 2 roles. There's got to then. You shouldn't hand a carte blanche to an employer, of course, to just make a business decision and present it to an employee with a fait accompli. But I think in deciding what fairness requires, you've got to be a bit realistic about what are the sorts of things on which an employee can realistically contribute.
Well, but of course, in, say, a collective situation, statutory collective, there is a requirement to consult on these sorts of topics. So one couldn't take as a starting point that employees are going to be unable to comment on these sorts of issues. They actually are able to comment on these proposals and to think about them. But my lord, my lord's question touches on a slightly different point as well, which I should just flush out.
Yes, certainly, please do.
You will have seen that my client has put in a respondent's notice, and it puts in a respondent's notice to essentially put this case on a very straightforward footing, which is the tribunal failed to consider the fairness of the consultation process in accordance with the well-known British coal standards. Now, if one looks at it through that lens, and if one asks whether the consultation was fair, then again, this is a common theme, as you will know, in public law cases. You have to start by asking, what did they consult on? And the point I would make is, they said that they were consulting on alternatives. So this way of putting the case, the respondent's notice way of putting the case, doesn't require me to say they had to consult on alternatives. It requires me to say they purported to consult on alternatives, but they did it unfairly. Because if you're going to say to your employees, we'd like to hear your proposals for alternatives, you have to make sure that it's at a formative stage, and you have to make sure that they have adequate information to comment on what is being suggested.
Look, I don't want to take you out of order, Mr. Jones, but to my mind at least, the fundamental problem with all of this may be that this is not how the argument was put before the ET.
I will come to that, my lord. I will come to that. Just while we're looking at this page, could I also just go back to another document you've seen, but page 40, the speaking note. And just to underline in that paragraph in the middle of the page, today's marks the beginning of a consultation
So
period.
where have we gone to now?
Sorry, page 40. So it's the
40,
speaking,
yeah.
speaking note.
The readout note.
Yeah.
During the consultation period, we intend to discuss the selection criteria and process we will use to determine which role or roles will be redundant. And the reason I underline that is my learned friend makes the point. He could have complained about the selection criteria. He could have made comments about it. That is not what is being said here. We intend to discuss the selection criteria, is what is being said. So that's how this has been presented to him in terms of the consultation.
We will use.
Yes.
Criteria and process we will use.
Yes.
Do you say, Mr. Jones, that if an employer had at least some draft criteria, in other words, you don't have to start with a blank slate, would you accept that much, that you are entitled to go into this saying, this is what we're thinking about,
Yes.
using as the criteria? They're draft,
Yes.
they're provisional, preliminary, however you want to put it. Is there anything you'd like to say about them?
Yes.
Would that be acceptable?
Yes, my lord, I'd go further, which is this. It's no part of my case that any particular process must be followed in every case, and that there are things which are in every case acceptable or not acceptable. It does depend on the facts and depend on looking at things in the round. The point which I make here is they gave him some selection criteria, which they said was an example. They said to him, we intend to discuss the selection criteria and process. But they hadn't, at that point, told him, for example, that they'd already scored him. And they didn't, as I'll come on to show you in the chronology, they didn't ever have a moment where they, quote, discussed the criteria with him. They had a second meeting, but there wasn't a topic, an agenda topic, discuss the criteria. It was just a meeting with him where a couple of things were raised. Obviously, I accept that he could have raised at that point anything he wanted about the criteria. But you just look at it in the round and say, is this, from his point of view, a fair process? That's the overarching question on these facts. And there may be different processes which are fair in different contexts. I mentioned the point that they didn't tell him at this stage that he'd already been scored, or what his scores were. Why is that significant? And I do make this point, it's particularly significant in a case where the scoring is subjective, because that in that kind of case, there is more scope for an individual employee to have input into the score. My learned friend said employees don't have input into scores. Well, again, it depends. They can. They sometimes do. The only point I make is that it is relevant to fairness that he'd been scored, wasn't told that, and it was a subjective process. Secondly, there's the point which I've already made about the resistance to change becoming built in over time, if I can put it that way. So the likelihood that they're going to revisit the scores later on is lower than the likelihood that they would have listened to him if they'd discussed it with him before scoring him. And thirdly, given that they had in fact scored him, and given that they had in fact decided that he was on their current scores the one in line for redundancy, one might have thought that just as a matter of fairness and being transparent about what is happening, they might have told him about that. Why? Well, it could have impacted on various decisions he made, could have impacted on his decision to engage more fully in the process, including in particular alternative employment, because that actually is another thing which happened at the same time as this consultation. And could I just show you that? If we go back into the judgment, page 86 of the core, he's had that first meeting, you'll remember from para 31 on 30th of June. And then the next thing that happens is the 3rd of July, para 32, he gets details of vacancies. And there were 2, but he didn't apply as they were less well paid and outside his skills range. Well, all right, employees often go through a redundancy process during which they may have opportunities to apply for alternative employment, but often those opportunities come once they know that they are the one likely to be made redundant. Now, again, here you look at this and think from his point of view, his employer knows that he's the one who's going to be made redundant, probably. He doesn't know. He's given this list of a couple of vacancies and doesn't apply for them. He's entitled to say, if only you had told me, if only the process had been transparent. It says at the end of para 32, the claimant was invited to the second consultation meeting with Evie Hancock on 8th of July, and he asked when, if he was redundant, he would be paid. That, I think, is the only thing that is said in this judgment about the second consultation meeting. But could I just emphasise that that's actually the only one of these 3 meetings which really involves any sort of consultation. There's 3 so-called consultation meetings. The first one, he has read out to him what's happening and it's news to him. The second one, a week later, is this one, which is dealt with in a sentence.
So I've lost the...
It's the end
here
of
we are,
para
yeah.
32. The third one, it's what they go on to in para 33, the 14th of July, is actually where he's told that he's the one being made redundant.
They hand him the letter.
Yes,
Dismissal.
of dismissal. Absolutely.
Sorry, he was told to be... Yeah, is that right? He was handed the letter there and then. He was told he was to be made redundant and handed the letter of dismissal.
Yes.
I thought that was slightly ambiguous, but you're saying that was actually at the meeting.
My lord, I don't know. I'd have to check that.
That's the way it reads, I have to say. Yeah.
Oh, yeah,
The letter's at supplemental 49 and it's dated 14th of July.
Yes, Ms Higgins reminds me that letter is in the supplemental bundle at page 49. I think you may have seen it, but it's dated the 14th of July, which would support that reading.
That's what I thought had happened. Yes, thank you.
So, now one thing which was said at this meeting is that...
Which one, 14? 14, you said at
yes,
this
one,
meeting?
one.
14.
Yes. No, I'm back on the 8th, sorry. Back on the 8th. On the 8th. The meeting on the 8th of July, that was the occasion on which the claimant was told that 2 positions were to be made redundant. And my learned friend said in her oral
Sorry,
submission,
I'm not saying you're wrong. It doesn't actually say that there.
no,
How do we know that's the case? We
we know it from page 109. This is what my learned friend took you to. It's page 109. We're in his witness statement.
You told us that the only reference to the 8th of July meeting was that sentence at the
Yes.
bottom of 32.
but you're saying it was in the oral evidence.
In the judgment, yes, yes,
only,
yes, yes.
only reference in the judgment, ET judgment,
Quite right, sorry.
to the 8th of July meeting was that single sentence at the end of paragraph 32.
Yes.
So where are we in the, sorry,
Supplementary
So
109. So in his witness statement, yes, I see. It's the middle of the page where, and he gives a little bit more evidence about this meeting. That's when he was told there's only 2.
Yes, that was when he was told there was only 2. And he says that he was relieved. But my learned friend took you to this to say he knew there were only 2. He could have made any submissions he wanted to the employer about alternatives to redundancy, because look, he did know that there were only 2. He found that out during the only meeting that was called to discuss, among other things, alternatives to redundancy. And he still did not, at that point, have any other information about the business case. I should, since you were asking me about the references to that meeting, just show you the other witness statement which deals with it, which is
Presumably Ms. Hancock.
It's Ms. Hancock, that's right. And it's, so if we go to page 121, I was helped, so paragraph 14, she was helped by Lucy and Delia. She allowed Delia to take the lead in sending letters and the consultation meetings. Delia wasn't a witness, but she led the meeting. And then over the page, 16, nothing happened in the consultation meetings with Mr. Haycocks to change my mind about my scoring. The selection of the 3 affected employees was finalised and a formal decision letter was therefore sent to Mr. Haycocks telling him his employment would terminate owing to redundancy. Well, that's literally all she says, but of course he at that point didn't even know he'd been scored. And there's no suggestion, and I think the minutes are in here as well, but there's no suggestion that she discussed the scores with him. She says nothing happened to change my mind. What?
But we clearly didn't, because we've seen the internal thing that he didn't know till after he'd been dismissed what the scores were, and they sent, and there's an oops email saying I thought he'd been told, but I gather he hadn't, so here I've sent them to him.
Yes.
Yeah.
Yes, and I apologise, I misspoke there, because what I meant was there's nothing to suggest that there was a discussion with him about the criteria and therefore what scores he should be given.
Yeah.
So, and more widely, as I've made the point, he couldn't sensibly have commented at that point on alternatives to redundancies. Could I just on the scores also pick up on a point my learned friend makes when she said he didn't ask for the scores during the process? He didn't know he'd been scored. So she says it's a two-way street, but it would be a bit odd for an employee to say, oh, I wonder, you're consulting me on these things, but I wonder if you've already scored me. Could you just let me know? And if you have, please provide the scores. So then from there, back in the tribunal's judgment on page 87, at 33, you have seen the final redundancy meeting on the 14th of July. The end of that paragraph is the reference to him asking why he couldn't be furloughed and the point I made about missing the cut-off date. There was then the appeal. Now, on the approach to appeals, of course an appeal might cure unfairness. One needs to look at the process overall, but it does depend on the nature of the decision and the facts of the case. There are appeals, especially in misconduct cases, where the appeal is really dealt with. We are discouraged, I should say, by authority from using words like full merits appeal or review hearing when describing internal employment appeals. But if you'll excuse me for using those terms,
yes,
some appeals are what we would recognise as full merits appeals, and that can essentially cure everything, and you have a different decision maker and an open mind. In a redundancy situation, of course it is possible that appeals could be done on the same basis. However, you get ordinarily, and indeed in this case, to an appeal stage at a point at which you've made a business decision that has become embedded over time, you've decided what criteria to apply. You might have consulted on those questions or you might not, but if you have, you've gone out to your employees and asked for input on those questions. And you've then decided which employees to make redundant. And all of that creates friction against the idea, if I can put it that way, that you're going to be entirely open-minded in reviewing the decisions you've made. Ordinarily, and I'll show you in a moment in this case, the process that you see is more akin to what we would call a review process. So one does with an open mind, an employer does with an open mind, and I'm not criticising the integrity of anyone involved in this process, but one looks at the process, typically, the arguments which are made, and if, for example, there is a criticism of criteria, as there was here, the decision maker at the appeal stage doesn't start again and ask what would be the right criteria with a mind as open as one would hope it would have been if it was raised in consultation. The decision maker goes, the appeal decision maker goes back to the individuals who made the decision, asks them why they use these criteria, says, that seems fine to me, and moves on from there. So, yes, an appeal can cure these problems, but it does not necessarily cure the problems.
It's a peculiar difficulty also, isn't it? Slightly different point, but while we're talking about appeals, in a redundancy situation.
Yes.
Because if the case being advanced in the appeal is, I should have scored higher than somebody else, that means that somebody else who certainly has not yet been dismissed and may well have been told they're not going to be dismissed,
Yes.
now has to be told they will be dismissed, or at least their case has to be reconsidered.
Yes.
So that it's not impossible, but it's a clearly very awkward managerial situation in a redundancy situation, where if you let one person off, somebody else goes back into the slot.
Absolutely. Now, during the course of his appeal, he learned certain things about the scoring. He was given his scores, but could I just show you a couple more pages in the supplementary bundle to highlight some more points relevant to this. Page 65
Of which bundle?
of the supplementary bundle, please. We're in an email dated the 21st of July. It's from Lucy O'Donovan at ADP to Mr. Haycocks, and she's responding to some questions that he had asked. And if you look at question 2, he had asked over what period was the assessment based, and the answer is the last fiscal year, July 2019 to June 2020. And then his next question is, what facts led me to receiving a much lower rating than in the performance review for the period ending 30th of June 2019? And the answer is that performance review was for the prior year.
And also using a different metric.
And using a different metric. Now, so that's the first point he learns only during the appeal process, is that they were looking at a different year to the one which he had expected them to be looking at. If we then go forwards, please, to page 78, I'm picking this up in the transcript of the appeal hearing. And there's a paragraph or a number 23. And this is
Remind me the date of the appeal hearing?
10th of August,
Yeah.
2020. So, where it's 23, Mr. Haycocks is speaking, and it's halfway through that paragraph that I want to pick up. He says, another piece of it that I'm curious about is who it was that was carrying out my review. Because in years gone by, in all cases, as far as I'm aware, it's the source's recruiter, by which he means someone at Goldman Sachs, who is the one who really has the most input as regards your performance. And I just wondered if that was the case again this time, if it was mainly Paul that was giving me my review.
And Paul is the guy with whom he'd fallen out, is that right? No.
No, Paul was another.
Was the
It was another. No, it wasn't the chap who'd fallen out with.
It was the
the
new
person-
guy who he was dealing
That's
with after he'd been moved, after he'd
Right.
been changed around.
Absolutely.
Yeah, okay.
So the question there is that someone at Goldman Sachs? Yes, he was my recruiter. And then he's told, so the assessment was done by Evie Hancock.
Yes, of course, right. Yeah.
And he says at 27, yeah, again, that's abnormal to me. And that discussion carries on over several pages. But again, he learns then that Evie Hancock was the one doing the scoring for the first time during the appeal. And if we just go back to page 66, please, you'll see his grounds of appeal. And one of the grounds on page 68, he called it procedural fairness. But at B, he's complaining about the nebulous, subjective and inadequate selection criteria.
Grounds for, sorry, I've dropped, which page are we going to?
Page 68
In the call,
in the supplementary.
in the supplemental.
So these are his internal grounds.
Oh,
for
I
appeal,
see,
which-
yes, okay. Yeah,
So he has a series of different complaints, but one of them is about the selection criteria. And further down, he has these points about, which you then see replicated in the ET1, which I'm going to come on to, but at E you have these points about him not knowing who was in the pool, not telling him his score until his dismissal letter, and so on.
well, what's the
And
point?
again, the point which I make is, during his appeal process, he was making a mix of complaints about the procedure that had been followed and about his scoring. And it's not until he's in the appeal meeting that he discovers that this has been done by Evie Hancock rather than the person at Goldman Sachs who he thought was going to do it. And when one comes to the criticism of him, to the effect that he hasn't been able, it is said, to identify errors in the scoring, it does, in my submission, miss this crucial point, which is he was arguing that the criteria were subjective and nebulous, and if he had had an opportunity to raise these sorts of points at a formative stage, it could have impacted on the decision. And critically, he only sees the significance of this when he's in the appeal meeting and discovers that it's his line manager who is doing the scoring, because he...
Well, hang on, let's just be clear about this. He does know from the date of the first meeting what criteria are being used.
Yes.
You can read them and you can form your own view about whether they're nebulous, subjective, and inadequate. That would be true whoever was applying them. That's the first point. And secondly, surely you would expect them to be applied by your line manager. Who else would do it? I know he says, oh, well, some of his performance appraisals had a feeding in by his clients, but you can't expect the client to decide who's going to be made redundant.
Well, so my lord, the several points wrapped up in that.
Yes,
firstly, the headline point which I'm making is that there is an interrelationship between the criteria and the scores, because in between those two concepts is the application of the criteria in your
Yes.
particular case. And he was told the criteria, but he was not told how they were going to be applied.
What does that mean? Sorry.
It means by Evie Hancock.
By whom they were going to be
Well,
applied.
not only by him.
And on the basis of what material?
And on the basis of what material? Because part of the factual background was he had longer service than most in the team, and he had felt that that should have been taken into account. But one of the reasons why they were only focusing on the last year was precisely because so many team members had only been there for a short period, and Evie Hancock only had access, as you've seen, to a short window of time since she had been the responsible manager. So those different points come together during the appeal process when it becomes clear to him that actually what is happening is these criteria are being applied not by the person you expected, but by your line manager, not using any longer period than the last year, and essentially using her subjective judgment. And he didn't have an opportunity to comment on what you might call the application of the criteria, but it goes hand in hand with the criteria. My Lord, I should respond also to the question of whether it was reasonable for him to expect that this would be looked at by Goldman Sachs. Well, they were working hand in glove. Maybe I should show you that actually the way in which this contract worked was that the company was essentially only servicing Goldman Sachs.
I got that impression, yes, that came over.
They were working, so it was
a one-client situation where you're almost part of the organisation for that
almost
function.
part of the
You know,
organisation.
I get that.
And so, and you see, I've made the point that the client had shared their own business thinking, and that was what fed through to the need for redundancies. He makes the point that his performance reviews did tend to be based on the person who he worked with at the client. That was why he had expected that.
Yeah.
So on the particular facts of this case,
Yes, I see.
you can well
Okay.
understand why he might have thought that they
Yeah,
were
okay.
involved. I accept that in fact they weren't, but that is why he expected it to happen that way. Back in the Employment Tribunal's judgment, page 87. You've seen already what is said about the appeal. But the only point which I make about this again is just to reiterate the point. It wasn't, there's no factual finding, if I can put it that way, that the way in which the appeal proceeded was with the sort of open mind on all questions that one would expect to see during a formative stage of a consultation process. How was this put in the Employment Tribunal? I need to come on to that. Can I ask you to turn in the core bundles, page 121, please?
Which page have we gone to?
121.
Yeah.
What document is this again?
This is the ET1, so the claim form. And it's under the headings, the heading there, failings in redundancy process, various points are set out. C is the criticism of the selection criteria. D over the page is also a criticism of the objective criteria. And then F is the criticisms about not giving him an opportunity to challenge various things. Now, just going through that list, little 1 and little 3 and little 4 all go. I apologise. Let me start that again. Little 1 and little 4 go to the question of alternatives to redundancy.
Is that right? You'll have to spell it out to me, but I understand the number in the pool for selection simply means we have got to get rid of X jobs. Doesn't matter from this point of view what X is, and the people from whom we're going to have to find those X are Y. So as it turned out, we're going to get rid of 2, and the people out of whom we're going to find those 2 is 16, or 20 if you include Warsaw. But why does that go to whether there should be a redundancy at all?
Well, my lord, I take the point. In the way that you just put it to me, my lord, I was treating it as involving both X and Y. In other words, not only, I accept that it only refers to the pool, but I was treating it as meaning the pool and the number who were going to be made redundant from the pool.
Well, it's certainly not what he was. He's certainly not what he was
I see
saying it on the face of it. Yeah. Okay.
So for
but just sticking with Y1, I know this isn't the point you're making, but so I can understand it. Why might it affect his ability? Well, I'll start again. If this had been drafted by an employment lawyer, and it's certainly been drafted by a lawyer, it's well drafted, you'd expect the argument to be, in a sense, as it was with the Warsaw point, well, you're only looking at this very small pool, so I only have a 1 in 16 chance, but you should be looking at this bigger pool, a 1 in 20 chance, or he might have said, although apparently this wasn't his eventual case, it should have been a 1 in 50 pool, because you should have looked at all the other teams. That's the point that I would have thought was being made there. May not matter, but I'm just trying to understand what the complaint was.
To pick me up on that, I think must be the point which is
yes,
being
I see. Yeah.
I see that. And indeed,
fishing in too small a pool, and therefore giving me a less good chance of escaping than I would have if you were fishing in a larger pool. Yeah.
Yeah, my lord, I'm slightly hesitant to sign up to that because I'm not sure whether that's the way it works out, is that they're in a smaller pool and could have been a larger pool. Can I just take instructions for a moment?
Why it's important, because I can imagine, suppose it's established that you had in this case a clear right to be told everything about the redundancy process so that you could say this isn't fair to me. And they said, well, we're getting rid of 2 people and we're going to look at the following, we're going to look at 16 to see how we get it from. He might want to say, mightn't he, well, you ought to look at a wider pool, actually. No?
My lord, I fully accept that.
I'm repeating myself.
The only reason I'm being hesitant is I don't know whether this company had more than that many employees in total, and I just need to remind myself before.
No, well, I was just doing the numbers from memory,
point.
And it's really just to understand what kind of point it was.
Yes.
Yeah. Okay.
My lord, I could just take instructions briefly, if that would assist.
Okay. Well, all right.
My lord, as I understand it, his concern was actually about the concern which you've identified, which is to say there were employees in Warsaw that you wanted to say should have been.
Yeah, that's fine.
So
okay.
That was the point.
Yes, sorry. Well, I've taken a long time to, but right. So that's what 1 is about, and then what you're about to say is 4 is about whether there's a redundancy situation at all.
Well, alternatives to redundancy, ways of avoiding redundancy. And 2 and 3.
And that means in practice going back to Goldman Sachs and saying, well, look, your report says you need fewer roles, but actually, do you?
Well, it wouldn't necessarily involve that. It might involve ADP looking at how, given what it expects the demand from Goldman Sachs to be, how it can deploy its workforce to meet that demand, which, as I say, might involve things like changing hours of work, those sorts of things, might involve furlough. But my lord, it could involve going back to Goldman Sachs, but that wasn't
okay, right.
What was in the main target of this. Scores at 2 is self-explanatory, so he hadn't been given his scores until after being told he was dismissed.
Yeah.
And 3 is provide me with the details of the positions, lengths of service and scores of those in the pool for selection. It's not a point which I do pursue now because we see in employment law terms the difficulties that runs into, but there it was. It was a point which he was also running at that stage.
It all seemed to be, at least understood by the employment judge, as being about the scores. You may say that she misunderstood the submission, but it's very much couched in terms of scores. In line 2 it says, did not give me the opportunity to challenge the scores and express my views on the matter. In particular, the company did not. Now, I know earlier there's a more general complaint, did not involve me properly in the redundancy process, but what on earth does that mean? That's just a sort of catch-all phrase that might be said. But what I'm really getting at is that nobody seems to have directed the employment judge's attention to the complaint which is now being made, but that he wasn't given the opportunity to comment on things like selection criteria at a formative stage.
Yes. Well, my lord, what I can accept, I have to accept, that the gravamen of the case that was put, it was the points which have been already shown to you, in particular about predetermination and so on. I accept that. And of course, one can see how it is put here, and there is particular emphasis on scores when you look at process. I accept that as well. I do make the point that he wasn't only talking about scores, but I accept that that is the thrust of it. Beyond that, I get into a bit of difficulty because this is my first appearance in the case, and I've tried to work out exactly what was argued at different stages, and I do run into some difficulty. But my lord, can I just show you on that point the Langston Authority, which is in the authorities bundle at tab 9, because I do rely on this in answer to that point, where it is said on page 93. You will see this arose out of a similar situation where it was being said that a particular point hadn't been argued below. So 1, paragraph 27, but subparagraph 1, the ineptitude of a party will not be a reason for permitting a new point to be taken on appeal. In this case, we're not satisfied the issue of pre-dismissal consultation was properly raised by the party below, nor was it raised by the Industrial Tribunal. However, the question of alternative employment after dismissal was raised and not expressly dealt with in the Tribunal's reason. Principles of law relating to unfair dismissals have developed since Jones. There was reference to Polkey. Where an applicant complains of unfair dismissal by reason of redundancy, we think that it is implicit in that claim, absent agreement to the contrary between the parties, that the unfairness incorporates unfair selection, lack of consultation, and failure to seek alternative employment on the part of the employer. There's no onus, so it has to be decided neutrally. In these circumstances, we think it's incumbent on the Industrial Tribunal to consider each of the 3 questions mentioned in 4 above, in the same way that an Industrial Tribunal will consider the threefold Birchall test in an appropriate conduct case. Now, well, it's true, as I've said, that the points which I'm placing emphasis on are not all developed in the ET1, of course they are not. It's also, however, true that this is a much more developed ET1 than employment tribunals often see. The fairness of the procedure was squarely an issue, and my Lord will need to reach beyond whether what I'm about to say is correct or not, but the sorts of points I have been making about the fairness of the process are basic points.
But the way it's particularised in ET is quite striking, isn't it? If you say, if it's right that you say this was a more particularised claim than you often get in ET1, is it therefore more striking if the particular specific issue is not alluded to, namely consultation in the formative?
They've hold against them the good job that they've done in trying to set it all out as well as they can. I mean, the employment tribunal.
Well, you don't get past in other areas of pleading, and I do, for being very particular about particular. You don't identify the right particular, and that's putting it rather brutally. But
no, I see the point.
That's the point against you, isn't it?
I see that point, but in a context where employment tribunals are used to dealing with litigants in person, and they know that this is a core issue, fairness of consultation, which ought to be considered by the tribunal. And of course, What I come on to argue is that they don't consider fairness of consultation at all. So this is my respondent's notice point, essentially, which it doesn't depend, that point doesn't depend on me taking the criteria argument, for example. It's a much higher level point about them simply not addressing their mind to consultation at all, in circumstances where he has set out clearly certain criticisms of the consultation process. I was asked about whether he raised the point about the timing of the scoring. No, he didn't raise it, and the fact that he was scored before he was given the criteria. The answer to that is it's not in the ET1, as you can see, but he didn't realise that that had happened until the cross-examination. So he actually didn't know that the scoring was done before the criteria were given to him until cross-examination.
Until cross-examination in the tribunal.
It's actually referenced.
Wasn't that apparent from the witness statements?
No, well, let me show you that. It's not apparent. If one goes, please, to E.B. Haycocks statement, page 121 in the supplementary bundle. See at paragraph 9.
I'm sorry, which page?
Page 121.
Thank you.
So you'll see the point is there at paragraph 9, and you can read, if you realise that what she's doing is approaching everything chronologically, then you could infer that this was done before the criteria were given to him. He, however, didn't realise it, and that actually is why the cross-examination, the note of the cross-examination, is in this bundle at pages 96 and 97, because he saw it as a very important moment in the evidence when he was told that the scores were completed on the 10th and 11th of June, and was not entirely sure whether it was accepted even now that that is what had happened. And he tells me that it was an important point in the closing submissions that were made on his behalf. I've heard what my learned friend says, and I'm sorry to have to put it that way, but I mean, I've not seen any note of it. I have no...
No?
Interesting. These are Dan's handwritten note of closings, and he typed it up. So that's an extract from the note.
Yes.
Oh, my lord, Miss Higgins again has rescued me. She has pointed out that page 99 of the supplementary bundle actually anticipates this point, because it has a typed version of the appellant's representative's handwritten notes from the closings, where you see the point. Not only was the decision made before the end of 2 weeks referred to in the letter, but effectively made not around 6th or 7th of July as I had worked out, but as early as the 10th or 11th of June.
So what's the decision there being referred to?
Well, I think it's the decision to make him redundant.
Yeah,
and
that's
they're
how I
linking
read it. That's how I read it.
That's how I read it. But he's linking it. He's not sure it's a refined way of putting it, but the point is he's linking it to the 10th and 11th of June when the scoring is done.
I understand that, but the trouble is that, I'm not criticising at all. We all have experience of this, and people have a sense of grievance, no doubt a sincere sense of grievance, and they feel that a decision in their particular case has been predetermined.
Yes.
But that's a different complaint when one stands back from it, from a different complaint that one could make if one has time to think about it, which is that they never had the opportunity to comment on the general criteria
Yes.
or other general matters. And it's the latter subject which has become central, as I understand it, to the present case now. It's moved a long way from, well, you had decided many weeks ago to dismiss me.
My lord, I have to accept that, and I hope I've already accepted that. But I've sought to show you that it was trailed in his ET1, if I can put it that way. It was a live issue in general terms, whether the consultation process was fair, and as the EAT has said, that is really a central issue in any redundancy dismissal case.
I understand how you put it.
And how is the point dealt with in the tribunal's judgment? Could we look back at that, please, on page 89? Now you'll see there's the heading discussion and conclusion. Now, my learned friend didn't take you to any of the paragraphs under that heading, other than the last one, which I'm going to come on to in a second, to show you that the tribunal had considered the fairness of consultation. So I'm going to take it that it's agreed between us that it's not discussed in those paragraphs. There are various other substantive points which are discussed. What my learned friend did focus on was para 47, which says, at the conclusion of the evidence, the tribunal will stand back and ask whether there has been a fair redundancy process overall. Now, in my submission, what the tribunal is clearly saying there is that after having looked at the particular points, the particular challenges that they're interested in, they're going to stand back and look in the round at whether this was a fair decision, as they are required to do, as the law makes clear that tribunals must do. It's a reference to a fair redundancy process, not a fair consultation process specifically. And it would be very odd in my submission for them to have thought that the way to proceed was to discuss all the relevant issues as they do at paragraphs 48 and following, but to leave the question of whether there was a fair consultation process to a sort of stand back at the end of their reasoning, which is, I think, what Leonard Friend says they did. So it would not make sense in my submission to approach a judgment that way. That isn't what they did. What they said was, we're going to stand back and look in the round at whether this was a fair, they call it a fair redundancy process. They just mean a fair decision to dismiss. They don't mean a fair consultation process. And I make...
In the immediately preceding paragraph, the judge has just said, fairness also requires consulting employees about the process.
Yes.
And giving them a chance to suggest alternatives. And it refers to the Williams and Compare Maxim case.
Yes.
As well as an opportunity to identify whether the selection decision may be mistaken or unfair. So,
but one absolutely, but one has to read it in the round. So simply reciting the law doesn't mean that they have then gone on to consider and apply the law. No. The question is, have they done that?
Well,
and
then it's more important perhaps to look at the discussion and conclusion rather than self-direction.
And the only reference that my learned friend went to was the last paragraph.
Yeah.
Which is 58.
Which is 58.
Yeah, which also refers to a fair redundancy process.
To which I underline redundancy.
Yeah, I see that. Yeah.
And it's pulling together the themes that they've already discussed. And then the next sentence focuses on the main point, which was the idea that the views of GS had influenced the process.
My sense, and this may not be accurate, which is why I raise it, so both sides can correct me. My sense of this section is that the focus appears to be on scores. And for example, at paragraph 56, we see that he has not demonstrated that his own score should be higher up the list and others should be lower. And I get a flavour that this may have been the focus of what was the main issue. Perhaps not the only issue, but the focus of attention appears at the hearing to have been about the scores, rather than, for example, some of the more general points that we've been hearing about, and what the EAT thought was fundamentally wrong with this judgment.
Well, my lord, the scores were certainly one of the points, one of the main points. Not sure I would describe it as the main point, only because when one looks at this discussion, there are various other points which he had highlighted. So the criteria for selection.
It's not necessarily a point against you. I don't know. It may be a point in your favour, or it may be neutral. But I'm looking, for example, at paragraph 53, where the judge says the difficulty with the claimant is that he's not been able to demonstrate that he should have scored higher. I just get a flavour, maybe wrongly, I just get a flavour that the focus of attention seems to have been about the scores this year, and perhaps not about some of these more general points. There may have been a reason for that, or there may not have been a reason for that.
The scores was clearly an important part.
Yeah.
There were various other arguments which were clearly important. The points which I have been highlighting clearly were not at the forefront of his submissions. I accept that. I have to accept that.
That's fair. Yeah. But you say they may not have been at the forefront, but they were there.
They were there. And certainly enough of them was there to mean that the tribunal should have engaged with the general question of fairness of consultation.
Can I ask you a specific question about the law, Mr. Jones?
Yes.
We've seen already that at paragraph 46, the judge did direct herself as to the compare maxim case. Is it part of your submission that there's enough in the compare maxim case to put an employment tribunal on notice that they should explore these other more general issues about the fairness of the consultation? In other words, you don't necessarily need to have the 4 criteria in the price case. Do you get enough out of compare maxim? That itself contains the relevant principles about what you should be consulting about. Do you want to look at that again?
Lord, I think the answer is yes, but maybe I should look back.
Is it worth just reminding ourselves of what it says?
If one looks then, Williams in the authorities, tab 1, page 9 of the bundle.
Yes, exactly. I don't know the answer to this question, which is why I'm asking you. But do you submit that page 9, C to G, is enough of a legal foundation that if you have in mind this decision, then you should be thinking about those principles?
My lord, I would certainly agree with that. I would, however, say that one should be thinking about these principles in any event, whether or not this case has been cited.
So by the principles, you mean the price principles, do you?
Well, I think my lord was asking me about the principles in Williams, so
Yes.
those principles, but the price principles also should be considered in any event. And they are different. Just looking at this now and asking myself whether they're different, I can't see in Williams immediately a reference to giving sufficient information to employees.
Well,
so that's I think the
point about consultation being at the formative stage, that phrase comes from price and is absorbed into the case law in this field after Williams, called price period-based.
My lord, yes, one might, I suppose, say that it's implicit, though, in the way it's put in little c on page 9. The employer will seek to give as much warning as possible of impending redundancies to enable union employees to take early steps to inform themselves of the facts, consider possible alternative solutions, and if necessary, find alternative employment. So the notion that it needs to be, here it said early, but what they're really getting at again is a formative stage, might be said to be implicit in this. The just looking at the list of authorities, my lord, if one were wondering whether they were aware of the British Coal Authority, that is, I think, mentioned in Biluan, which is cited in the Employment Tribunal's list of cases on page 89.
Well, it comes in at Rao, isn't it? Initially. And then it's repeated in various other cases after Rao.
Ah, yes. Sorry, I was just looking at the cases which the Employment Tribunal cites on page
Yes,
89 of the
yes.
manual, so yes.
Yeah. So, is it your submission in considering, standing back and considering the fairness of the process, the tribunal does that by reference to principles established in the case law of which it has general knowledge, whether or not they're cited to it?
Well, on the specific question of the fairness of consultation, they ought to have posed themselves the question whether it was fair on the basis there of the Langton Authority, even if it had not been cited, even if it had not been raised in the ET1. Now, if they'd asked that question, which principles ought they to have applied? They say the British Coal principles. My lord's question, what if that case hadn't been cited to
Well,
them?
I mean, as I understand it, I mean, correct me if I'm wrong, your proposition is that as part of it, assessing the fairness of the consultation process, standing back, when you do that, the tribunal judge has to have in mind the relevant principles.
Yes.
And it's not just the principles in Williams, but it's also the specific 4 principles derived from Price and then absorbed into the case law, as we've seen in this field.
Yes, my lord.
And that's even where, as here, there is a particularised complaint which doesn't refer specifically to the point now being taken. This is the point now being taken. Or taken in the EAT.
Well, my lord, yes, but I'd put it the other way round. I would say especially where the fairness of the consultation has in some form been raised in the pleadings, albeit that it may not have raised every point.
All right, so there's the general fairness and the particular. So there's an assertion of general unfairness, as it were,
Yes.
and then particulars.
Yes.
But the particulars are not the only particulars, they're just some of the particulars, which
Well,
the tribunal has to have in mind in considering the overall fairness.
Yes, I mean, some of the particulars go to the fairness of the consultation process, but yes, it's true to say that they don't make all of the points that I've made today. But my lord, could I just make sure that I've made this point clear, which is that mostly what I've been saying so far goes to what I keep calling my respondent's notice point. And I'm going to come on in a second to the EAT's judgment, but I do just underline that the respondent's notice point doesn't actually depend on, for example, the criteria having not been consulted on properly.
No.
It goes no further than to say he raised certain points about the fairness of the consultation process, and they are not addressed.
Yeah.
The criteria then comes in when we look at the EAT's judgment, where obviously it's much more important.
And just flagging up something, don't deal with it now. But we will have to look at it when we get to the end of your submission.
Quite
Your
soon.
point, sorry?
Quite soon.
Quite soon. Your point is that these points were raised and were not addressed.
Yes.
Yeah.
It is not on this bit of your argument that there was only one answer to them if they had been addressed.
Well, that's fair. Of course, he did say in the EAT that they could essentially decide it on that basis, as a remedy point. But yes, on the pure way that the respondent's notice point is put, my lord, that's right.
Can I ask you, well, maybe the same question, but in a different way? Do you submit that your respondent's notice point in this court is the same as ground J in the EAT, which is the only ground that actually you had permission to argue, or at least the only ground that was pursued? ground J, is that what this ground is?
Yes, it is, but let's go to ground J.
Yeah.
It has to be really, doesn't it?
I
Because
mean,
you
it
end
has
up
to be.
permission to argue anything else.
Yeah,
Yeah.
Well, that's why I
well,
asked the question.
my lord, I think in fairness, I haven't got permission to argue the response notice point either. I meant to flag.
Well,
actually,
you
my
more or
flag-
less have, because Ms. Atiru, while reserving right to come back to you if necessary,
Let me move to ground J. So that's in the core bundle at page 71, and then that's a good stepping stone to then look at ADAT's judgment.
Yes.
The judge completely failed to deal with the claimant's contentions that A, the constitution of the redundancy process was fundamentally flawed, and B, its implementation was equally flawed. So the heading there is, yes, my heading for the respondent's notice point.
Does this refer to the fairness of the consultation process?
Well, my lord, that's how I've when one reads it as against the skeleton argument, where the consultation process is what is focused on, that is certainly how I have understood it.
Can you take that in turns?
Yeah.
I'm sorry if I appear to be a stickler for procedure, but I probably am. I usually take the view that grounds of appeal are different from submissions in a skeleton argument. But let's leave that to one side. Focusing just for the moment on page 71, does ground J plead the point that the consultation process was unfair?
Yes.
Right, so that's your submission, fine. And then you're going to take us to the skeleton argument in the EAT.
You can see the skeleton argument, but I'll just remind you, it's at page 14 of the supplementary bundle.
I just get that again. Yeah, paragraph 2.
Yeah, paragraph 2.
And I suppose you would that paragraph 3 and following as well. Paragraph 3 and 4.
Yes.
But here we see very clearly now, possibly for the first time, an express reference to the British Coal criteria.
Yes, we do see that. Is it the first time? Could I ask my junior to tell me if there's any other time that
Yes.
I've forgotten? But yes.
I can perhaps help. It was referred to in the decision on the SIFT at page 77.
Oh.
sorry, can you speak up?
It was referred to in the decision on the SIFT in the EAT.
Yes, I
at
see,
page
thank you.
77.
Right, thank you very much. But here, certainly, am I right to understand the gravamen of this ground J, is captured at paragraph 2.4? The tribunal did not consider this question at all. I know there's an alternative as well, but
Yes,
is that really the heart of this complaint?
that's the heart of the complaint.
Can I, sorry, it's not helpful having, particularly this time on a Friday, having questions from all sides of the court. Just help, and this may be my ignorance. The constitution of the redundancy process is what it says at JA. What precisely does that mean?
Well, my lord, it's not a term of employment art, as far as I'm aware. So I have read it as meaning the manner in which the process was rolled out, i.e. the consultation. That's how I've read it. That's why I answered yes to my lord's question.
I
But it's
wondered
not.
if it was, I actually wondered if it was a misprint.
It could even be.
What is it looks, if it isn't a term of art within the employment redundancy process, it's rather an odd word to use, isn't it? What does it mean?
My lord, that's the way that I've read it, and I don't have any other.
I mean, it could just, if it said consultation, it would make obvious sense, wouldn't it? The consultation and the implementation, two things wrong. First of all, the consultation was flawed, and secondly, the way the process was implemented was flawed.
Yes. Yes.
And that it also actually ties it closer to the skeleton.
Yes. So then the EAT judgment.
Just perhaps, do we get any help on that? Well, Judge Beard's reasons for allowing it to go forward at 77, at which point, just remind me, I ought to be on top of this by now. Yes, at which point he had seen, he hadn't heard the oral argument, as he did on the papers, this is a 3-7, but he'd seen the skeleton.
No, he wouldn't have seen the skeleton. That
Would
have
literally have just seen the grounds.
Yes, unless any additional submissions had been filed with them, but probably.
But he certainly interpreted it as J and L together, he certainly interpreted as being a point about consultation.
Yes.
So even if there was some doubt about what J meant, looked at cold on page 71, there's no doubt about the basis on which the judge allowed it to go ahead.
Yes.
Yep, okay.
My lord, the EAT's judgment is where I was going
Yes.
to next. Paragraph 1, you'll have seen that there's a reference to placing particular assistance or obtaining particular assistance from the lay members, which is obviously important given the discussion of good industrial practice. Paragraph 3 is where the ground is described. And my lords, I have to accept it just is not a very clear description of what the ground was understood to be. I accept that entirely. It builds up at the end. What I say is the key point, which is that the tribunal had not considered the consultation. They say adequately or at all, but the real point is they didn't consider it at all. Part of the reason, but it is, I think, only part of the reason why the judgment is a little bit difficult to disentangle when you come to the questions of rationality is because they do deal with remedy at the same time. In other words, there isn't a separate section on whether or not the Jaffrey question has been satisfied when I say remedy.
Yeah.
So they're looking at things in the round, the ground of appeal which has been put, and the question of what they should do at the end of the case. But there is also another reason why they approach it in this way. And to see that, you need to go to, firstly, para 21. Where the tribunal makes clear that they fully understand that the statute is the keystone. They make clear that they fully understand that guidance is just guidance. If despite the guidance, the process adopted by the employer falls within the bound of reasonableness, an ET must find so. However, they say the purpose of guidance from the appeal courts is to inform the question of reasonableness, and if the guidance does not apply, ETs would be expected to explain why it did not in the particular case.
Yeah.
And you see there's a sort of running together of two slightly separate concepts. But what the EAT is saying is they are going to start from the question, essentially looking at the facts as found. Was this, on the face of it, within the range of reasonable responses? And of course, to do that, you have to take account of what good industrial practice is, which I'll come on to in a moment. But then they're saying, well, if on the facts as found, it looks as though it's not within the band of reasonable responses, you ask this next question, has the ET explained why the usual approach did not apply in this case?
Yeah, well, one can see why it does that, yes.
One can see why they approach it in that way. It does accept making.
But it's effectively, that's effectively what Compound Matt Simon Williams says.
Yes. Yes. So in broad terms, the question is, did the employer, or here, because we're at the appeal stage, did the ET consider good industrial practice? And if not, did they explain why not, or did they explain why they were not following it? That's the broad framework of their analysis, their approach to this issue. And it's then from that starting point that you get the discussion about what is good industrial practice.
Yeah.
And I'll come back to this in a moment, but could I just, as I'm going through, could I just show you on 28? In fact, my lord, I think my lord made this point just after the short adjournment, but they're interested in 28 in the opportunity to propose other means to avoid the redundancy situation. And then over the page on 31, they're interested in the opportunity to comment on the criteria. So it's those two facets of the consultation that the EAT considers to be important. And then when one comes to para 32, again, I accept this is just not the clearest way that it could have been put, but what is being said is there was no consultation at the formative stage. There's nothing in the judgment which indicates there were good reasons not to discuss this at what we have described as the workforce level of consultation. So there wasn't, as a matter of fact, consultation at the formative stage. We can't see any reason why it wouldn't have been discussed and consulted at that level. It means there was never any opportunity to discuss the prospects of a different approach. And then the absence of meaningful consultation at a stage when employees have the potential to impact on the decision is indicative of an unfair process. And of course, that third sentence, it means that there was never any opportunity to discuss the prospects of a different approach to any aspects of the redundancy process chosen by the employer, is quite a strong way of putting it, given that, as you have seen, he was told the criteria, he was told that he could suggest alternatives. I accept that that is a strong way of putting it, but you need to read it in context. What they are really saying is that there was not meaningful consultation at a stage when employees have the potential to impact on the decision. That is what is indicative.
I read that, as you say, it has to be read in context. I read that as being their elaboration of what is meant by the formative stage.
Right.
I don't think you need to shy away from the proposition, which is well founded in the authorities, as I understand it, that formative means precisely that you must be able to participate in the consultation process at a stage when there is the potential to have an impact on the decision.
Yes.
Certainly speaking for myself, if and to the extent that the public law principles, which seem to be the genesis, I mean, they're straight out of a case called ex parte gunning, which is the locus tascus of the fourfold test for a fair consultation process. That's 1985. As it happens, it was Mr. Justice Hodgson, who then, I think, approved himself in ex parte Bryant. Then the ex parte Bryant gets approved by Lord Justice Glidewell in the British Coal case, which I keep calling ex parte Price, I think, in the Court of Appeal, I think. That's
Divisional Court.
Divisional, sorry, forgive me. And so that's the genesis of this, and then it gets applied to the employment law context in later case law.
Yes.
Now, if this were a public law case, speaking for myself, it would not be a sufficient answer for a public authority to say, we consulted you at a formative stage because although we had decided something, it was always open to you to say you disagree and we would have listened to you.
Yes.
But that's not what's meant by formative. Formative means, we're familiar with it. You know, when the government publishes a white paper or something like that, it puts out a consultation. It says, this is what we're minded to do at the moment. These are our draft policies or draft legislation, whatever it may be. What would you like to say about it? And we're all familiar with it. You often get 30 questions at the end, the consultation questions. I mean, that's what's meant by consultation at a formative stage.
Yes.
Otherwise, you would have the government has decided it's going to do this, And of course, it's always open to you to say, well, don't do that, and we'll think about it if you make that point. So but I think the fundamental problem you've got in the present context is that none of this, at least specifically, was raised in the ET, but that's terrain we've already gone over.
Yes, well, my lord, the only additional point I'd make to that is I would accept that the application of the requirements of a fair process has to be alive to the fact that this is an employment context, not a public authority. I accept that. So I just want to make clear, I'm not suggesting that precisely the same standard would be expected.
Well, that's
to
a
be
very
adopted.
fair acceptance of a sensible point, if I may say so.
My lord, just on the British Coal case, I noticed looking at the list of counsel that you had against you our current Prime Minister, who was apparently for the NUM in that case, which
God,
was,
I hadn't
think,
even
the th- I think it
noticed.
was the
I'm
third
so solipsistic. I noticed that I had appeared. I hadn't bothered to notice who was against me.
I even wondered whether it might have been.
Lord's been so busy reading over lunch, he's probably thinks you're still referring to.
I actually,
Mr.
when I saw the case referred to, I did quite forget I'd been in it, but I then eventually.
Who won?
Oh.
My lord.
I
Well, there you go.
Despite the fact I see that I had 4 juniors against me, one now in fact, a remarkable team. One now and for many years in the House of Lords. One a distinguished High Court judge recently retired. One the current president of the EAT, and one the Prime Minister.
Yes.
But me and Ms. Lerble were up to it.
Well, they all decided to move on to something else, having been now nearly defeated. Yeah. 32 is not a very. Paragraph 32 is not a happy paragraph.
It's not.
One of the problems with paragraph 32, if I may say so, is that the EAT appears to be asking itself the question, rather than asking itself the question, did the ET err in law in answering this question?
Yes.
Well, I see that, but firstly, when one is making an argument that they erred in law in failing to address a particular point, one is inclined to start, as I have started today, by showing that the point has some force to it. And one can understand in that context why the EAT may have approached it through that lens as well. Let's look at what the facts were and whether the ET should have given reasons in the particular facts of this case. And layered on top of that, there was the Jaffrey question which they needed to address. Now, they don't explicitly address that.
Well,
but
it says they take it the other way round, because
the other way around.
by saying head on that, no, I mean, there's no way in which it can be completely satisfactorily explained, paragraph 32, but you can sort of see where they were coming from. They were sure this was unfair.
Yes.
Once they'd reached that point, the Jaffrey question doesn't arise. And perhaps it doesn't really matter to them whether their point is that the tribunal set about it the wrong way or asked itself the wrong question.
Yes, quite.
But we'll have to grapple with that.
Paragraph 32 would make more sense if the sentences were in a different order.
If the sentence...
Yeah.
I mean, I don't. Why? The second, the key proposition, the third sentence, doesn't follow from the second sentence.
Yeah.
When it says, there is nothing in the judgment which indicates there were good reasons not to discuss this at what we have described as the workforce level, it means there was never an opportunity to discuss the prospect. It's
yes, yes.
the central proposition is that the EAT is satisfied. It asserts the absence of the fourth sentence, the absence of meaningful consultation at a stage where employers have the potential impact on the decision is indicative of an unfair process.
Yes.
That's the proposition.
Yes.
Now,
No.
I noticed the time.
Yes.
I noticed there's a need for a reply.
There
I
is.
do actually feel, well, there may not be a need for a reply, there's a need for an opportunity for a reply. I do feel we've got to the heart of this, but I just wanted you to make sure that there aren't any points that you haven't had the opportunity to make.
Well, my lord, just this point. In fact, it's really a point which doesn't go anywhere, in the sense that I haven't addressed you on the cases which might be said to go to the question of what is good industrial practice, and you've got compare maxim, but then you've got the case which actually is in the authorities at tab 2, the Freud case, and then my lord's decision, and there's the discussion of what one would expect to see in different contexts.
Well,
I've not gone to that because it's a question of fact, really, for the EAT, and the point that they make and is made in Williams is the EAT is a special court because it's got lay members with experience of employment cases. And so, and my learned friend in her opening remarks made some comments about this changing the approach, but I don't think ultimately any of the actual grounds which are being run are straightforward challenges to what the EAT says good industrial practice requires in this kind of case. So
how that translates, those principles in compare maxim are a fairly high level of generality,
yes.
and are larded with cautions about, don't take these as rules, there are any principles, and every case is different, and so on. Read in that way, the question is, well, how do they apply on the facts of this case?
Yes.
Including a particular feature which we've now looked at carefully, the way in which it was presented in the ET.
Yes. Well, my lord, there is an extension. To be clear, there is an extension from compare maxim, because compare maxim is about a union situation.
Yes.
And they make that clear. Freud is a non-union case. Actually, if you read Freud really carefully, it's quite difficult to work out what the difference is between Freud and compare maxim.
Compare maxim is mostly about unions because those were the facts of the case. But most of it is transferable mutatis mutandis to a non-union situation. And you may say that's what Freud illustrates. It's been objected to you but I noticed that no real point was made about this, that the tribunal shouldn't have relied on Freud when it wasn't referred to below, but that's not her best point, as she's shrewdly noticed. But none of this is really about the law, I don't think. It's certainly not about Bill 1 against Morgan.
No.
You must make any submissions you want about the cases, but our instinct is exactly the same as yours. I think I speak for all three of us.
In that case, I have nothing.
About Jaffrey, he's going to speak about Jaffrey.
Yeah, well, my lord rightly reminds us about Jaffrey, but in a sense that all also depends on whether the tribunal, the EAT, was entitled to reach the conclusion that there was only one answer to this.
Yes.
If they were, then Jaffrey doesn't arise, or
yes.
That is the Jaffrey question. But if it was, or should have been, only a decision that the right points were not considered, then I think it's going to have to go back, isn't it?
Well, my lord, the claimant has put his case on the basis that in that scenario, you would be able to decide that there is no reasonable decision open to the Employment Tribunal other than that it was unfair.
But since the EAT's already done that, unless we think this only arises if we think they weren't entitled to reach that conclusion.
Well, it arises if you disagree with their reasoning but agree with my respondent's notice point.
Oh, I see.
Have we got all the material we would need to do that?
Well, you could only do it if you felt that you had all the material that you would need.
Well,
so my answer has to be yes, but that's. Well, but my lord, I've trivialised it somewhat. But you saw, I tried to take one reason why I took you through the criticisms that I make of the process as I went through.
I mean, haven't you demonstrated on your case there's ambiguity, or accept there's ambiguity in some of the emails, etc. Insofar as we have to evaluate them ourselves.
I don't.
That wasn't what you were trying to do anyway.
My lord, if I can put it this way, I wouldn't accept that any of the points which I have been making positively about unfairness rely on any ambiguous emails.
Yeah. But I think we all understand what the nature of the exercise we've got to go through is, whether we do it at the Jaffrey stage or at the
Yes.
at the stage of allowing the appeal, or just determining whether the appeal should be allowed. Well, that's been extremely helpful, and unless there's anything more you feel you've got to say, Mr. Ashlew, is there anything you need to say?
Perhaps if I could just make a few points,
Yes.
if I may. Firstly, there was discussion of public law principles and how the guidance as to formative stage of consultation arises. Of course, I'm no public law expert, so I can absolutely defer to your greater experience in that respect, of course. But I understand that obviously there are greater checks and balances in public law cases, whereas in the tribunal, we are looking at the broader discretion as to whether or not the employer's approach was in the band of reasonable responses. Now, of course, even if there was a failure at the formative stage, we say there wasn't, but even if there was, that doesn't necessarily render the dismissal unfair, and the tribunal was perfectly entitled to take a stand back and saying, knowing what I know about the selection criteria, the process, the way it was applied, Ms. Hancock's good faith, etc., I still think that this process overall is fair. So that's the point in relation to that. Now, it's been said on paragraph 32 of the EAT's judgment that the way it put paragraph 32 is in strong terms, but paragraph 32 is factually incorrect. To say that there was never any opportunity to challenge any part of the process is factually incorrect for the reasons I've already addressed you on. There was a point made about what constitution means in ground J of the grounds of appeal. I did check back on my note on this because Mr. Haycocks Senior referred to those particular words in closing submissions, and that related back to the letter at page 38 of the bundle, the 30th of June, the at-risk letter, and in particular the point that we have canvassed today about the decision being predetermined because the scoring was done at an earlier stage. So it wasn't specific about the consultation being.
Yeah, well, I suppose you're right about that, and you may well be. I mean, you uniquely been at this throughout. Am I not right in saying that, rightly or wrongly, Judge Beard took it as being about constitution?
Consultation.
Sorry?
Consultation.
About consultation, sorry, it's time of the afternoon. And gave permission explicitly on the basis that that's what this ground was about. That's what we see from page 77.
You may well be right on that, my lord. But of course, it comes back to what the claimant was arguing in the tribunal and what his points were on consultation at the tribunal. Now,
sorry, perhaps I didn't write down what you told me, but you say
it was about predetermination of the final decision because the scoring had been done.
Yeah, certainly
the Constitution's on word to discover that too, but to cover that too.
It's in two paragraphs. There's paragraph A and paragraph B. Paragraph B certainly reads as if it's about that issue. I have to confess, I don't understand what paragraph A is.
No,
but it was settled by the claimant, was it?
By his father.
Settled by the claimant's
By his
father.
That's right.
The litigant, as litigants in person at the time, so weren't represented.
It does look to me, for my part, as though the judge read it as a misprint and thought it was about, because then he goes all into consultation, and that's what the skeleton says.
Well, I have to confess, I also read
confusing.
it as consultation when I first read it, but it's actually consultation.
But if we look at 77 of the core bundle, the judge was actually giving permission on J and L, but none of his observations really go to L, which is about the scoring and references to British Aerospace and Green and so forth.
The final sentence.
Sorry?
The final sentence does.
That's scoring.
Oh yes, sorry, yes, you're right. That's about that, right? Everything down to the last sentence, you're quite right, is clearly about so he must have understood J as being about consultation, and it's not completely odd for him to do so because B is sort of about consultation.
Yes.
But this is just archaeology, isn't it? It can't be wrong to treat the ground of appeal, which was properly before the EAT, as being as glossed in the reasons on page 77, can it?
I accept that, and that's why we broke our submissions down in the EAT in the way that we did.
Yeah.
But it is fair to say that it hasn't been entirely clear throughout the process what point the EAT is addressing, and upon reading the judgment, it became even more unclear because it seemed that the EAT was saying something that wasn't in fact discussed at the hearing itself.
I mean, these are cases the judge refers to which had not been referred to in any of the papers before him.
Yes.
And what it looks like, I don't mean this in any way rudely to the judge, is these were points that were of interest to him. He'd already, as it happens, recently done a judgment about them in Mogaine. And I think he thought this is a case which raises those sorts of points. It, to that extent, is a rather EAT-driven point, although
Yes.
Mr. Horan obviously, like any good advocate, ran with them.
I mean, you could, in response to that, you could say that if he formed the view that constitution was a misprint, then it does put the overall consultation process absolutely centre of the appeal, doesn't it?
But
It opens up the whole issue. Consultation is fundamentally flawed. The whole, that's what, if we read constitution, several of us seem to have done initially, for constitution, read consultation, then the whole thing is open.
yeah, but I think,
But then,
but your explanation, for better or worse, but you've told us, is that that is a word that was used by Mr. Haycocks Senior with a particular meaning.
yes.
Well, there we are. I think we've explored this as far as we can. What are your other?
I just wanted to say that there's been reference to whether these more general issues about consultation were canvassed below, and whether Williams was enough to show what the tribunal should be considering. With respect, I think that's the wrong way round, because I think the general issue is whether consultation was fair, and these more nuanced points about whether there was consultation on the selection criteria at a formative stage is a more specific argument that wasn't canvassed at the tribunal hearing, and there isn't any general guidance or established principle that is something specifically that she would have to put her mind to in this case, especially when it wasn't argued before her.
Did you, so if we have in mind page 77, because I think it's a very useful place to consider this question. There, the judge in the EAT, in granting, as it were, permission to go forward, expressly refers to the British Coal case, expressly sets out the 4 criteria for consultation in that. Now, is it any part of your submission? I ask this because it may be, I don't know. Is it any part of your submission that actually if these sorts of questions are to be properly addressed by an employment tribunal, they could well require evidence, and that these sorts of things would have to be explored in evidence? Is that part of your case?
Well, yes, of course, because the tribunal would have to determine overall whether there was an issue at the formative stage and whether or not that rendered the process unfair ultimately.
Well, right. If nobody at the employment tribunal hearing is conscious that these are the questions they should be thinking about, then could it be the case that they won't have addressed it in their witness statements, they won't be cross-examined about it, submissions may not be made about these points?
Well, I think it's a slightly different point because, of course, the witnesses just go through chronologically what happened in terms of the process. This is perhaps more a submissions point, and this is why we come back to what's relevant is what the claimant argued in the tribunal.
Yes.
So, I think
were there any gaps in the evidence? Were there any matters which the evidence would have covered if the case had been formulated on the basis of the price criteria from the outset?
in terms of the evidence, probably not. I think the chronology would have still been the same. The evidence would have been the same. In terms of the judgment and the particular issues, then perhaps different parts of the factual background might have been focused on. I think the key thing here is that firstly, an employment tribunal is not expected to refer to every guiding principle, so not expected to have referred to the British Coal case, and it can't be said to be an error of law that she didn't refer to that case. And we know that she did cite Beluan, which sets out the principles in Price itself, so it cannot be said that she didn't have those in
You
mind.
keep saying that, is that right, by the way?
Yes.
Okay. No, you say it firmly. I'm not even spend time looking. I trust you.
Yes.
Belaine.
Sorry.
Belaine, sorry.
Yes. So sorry, just give me a moment. So it's tab 15.
Well, we can look for ourselves.
And it's cited from the tribunal's judgment in that case. I think it's paragraph 18, but just let me check.
Oh, I see. Yes. Okay. Thank you. Right.
So that's that point.
That's that. Now, how are we
So
doing?
Just a couple of more things. My learned friend today has made a number of points in respect of his argument on the adequacy of the consultation or the information provided. Of course, all very well and good now, but not points that were raised at the time. And one point he made was that the claimant didn't know that Miss Haycocks was the one scoring. But actually, if I can find the right bundle, if we look at page 40 of the supplementary bundle, the script that was read out to him at the first meeting specifically states this messages need to be kept confidential and it cannot be discussed with the client, which would show that this was an internal ADP process and not scoring done by the client.
Yes.
My learned friend made submissions about the appeal stage not being able to correct these earlier errors and things being embedded in the minds of people the longer that time goes on. But of course the tribunal heard from Miss Haycocks specifically, and this was a key point that Mr. Haycocks put to her about predetermination of the decision, and she did give evidence on what the process involved and the final decision not being made until the end. And equally, the tribunal heard from Miss Jones in relation to the appeal process and made specific findings about the appeal at paragraph 56 of its judgment. Now, my learned friend today says that the claimant is entitled to say that if only you had told me these things. Yes, he's entitled to say that, but he didn't say that at the time, and that was not part of his case previously, and the EAT didn't decide this case on the basis of inadequate information. And then the only final point, my learned friend took you to paragraph, let me just turn it up in the tribunal decision. He took you to the paragraph about what was decided on the 18th of June. So that's paragraph 29 of the
Yeah.
tribunal decision. And in fairness, you should also look at paragraph 50 of the tribunal decision, where the tribunal judge refers this as being in this exercise. It's on page 90. In this exercise, the employer proposed to dismiss only 3 employees. So, in the tribunal's view, this was still a proposal rather than a decision that was set in stone. But those are just the points that I wanted to come back on, unless there's anything else I can assist you with.
Not as far as I or my lords are concerned. Well, thank you both very much, and those behind you for your submissions or your contribution to the submissions. We will obviously be reserving our decision. We will try to get out as quickly as possible, but may not be very quick. We will follow the normal procedure, which I think at this late hour I won't explain to 2 experienced advocates like yourselves. I just really want to remind you that when you get the judgments in draft, you are constrained by the principles clearly explained in the Consul General for Wales case, and you or others behind you could get into serious trouble if material is used for any other purpose. Thank you very much.
Court rise in favour.
Thank you.